So, very interesting document came out today in the Idaho 4 case, State versus Kohberger. It was filed by prosecuting attorney Bill Thompson, and it involves Brian Kohberger's alibi defense. Basically, the state is saying that what was submitted doesn't constitute an alibi. And I kind of wondered that. I had been debating with people on the interwebs for the last couple weeks about the alibi defense, and I was saying that by the deadline, they had to turn in specific times, locations, and witnesses. And I had people telling me that no, that's not true. Idaho law is very vague. Anne doesn't have to turn that in. She just has to say that they're going to use an alibi defense and that she can prove he was elsewhere. I was like, no, you have to give specifics over to the prosecution because they have to be able to start researching those times, places, and witnesses so that they can rebut it at trial if needed to. So let me show you the Idaho law before I show you this document that Bill filed. So here is the Idaho law about alibi defense. So the notice of a defense of alibi. You'll notice where I highlighted, it says, such notice by the defendant shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such an alibi. So if we go back, just as a refresher, and look at the defendant's alibi, you'll see that it actually does not give you any times in here. It just talks about how he would explore the park. And then if you go to the next page, it just says that his phone shows him in the countryside late at night and or early in the morning on several occasions. The phone data includes numerous photographs taken on several different late evenings, early mornings, including in November. Says he was out driving in the early morning hours of November 13th, 2022. Notice it doesn't say what time, just says early morning hours. In fact, they don't even say 4 a.m., which was around the time of the homicides. They just don't give a time at all. Early morning could be a wide range. Then it says he drove throughout the area south of Pullman, west of Moscow, including Wawawi Park. Really doesn't say specifics other than the park. A park, which I might add, was closed, which means if he was in the park, he would have had to climb over the gate. So this was not specific at all. No specific times, nothing. And no witnesses named. All they can say is that Cyree can partially corroborate, but that's not an eyewitness. So I knew this alibi was lacking, and I was expecting Bill to file an objection to it. So now that we've had the refresher about the state law and the alibi document that the defense submitted, let's take a look at what Bill filed today. So this is a response to notice of defendant's supplemental response to state's alibi demand. And I started highlighting where it is important. So it says, the state respectfully submits that the defendant's supplemental alibi response continues to lack the specificity required by Idaho Code 19519, which provides that the defense shall state the specific place or places at which the defendant claims to have been at the time of the alleged offense and the names and addresses of the witnesses upon whom he intends to rely to establish such alibi. Emphasis added. So then it goes on to say, with the exception of the reference to Wawawi Park, which is new, the defendant is offering nothing new to his initial alibi that he was simply driving around during the morning hours of November 13th, 2022. You can read these sections, you can pause, then I highlight it again. as to the defendant's reference to potential testimony about the location of defendant's cell phone on the morning of November 13th, 2022, this information does not rise to the level of an alibi at the time of the homicides because the defendant's cell phone stopped reporting to the cellular network before the homicides and continued to not report until after the homicides. So it talks about location of the cell phone. Then it says it is the state's position that the defendant's continued failure to adequately comply with Idaho Code 19519 does not trigger a response to Idaho Code 19519. If the court deems the defendant's supplemental response to be in compliance with the requirements of Idaho Code 19519, the state requests additional time pursuant to Idaho Code 19519 to prepare a list of witnesses to establish the defendant's presence at the scene of the homicide. As to witnesses to rebut a claim of alibi, the defendant's failure to adequately comply with Idaho Code 19519 means the state does not know what specific assertions need to be rebutted. If the court allows the defense to offer further witnesses or information regarding the alibi, which the state opposes as described below, and bring into compliance with Idaho Code 19519, the state will then respond accordingly pursuant to Idaho Code, you guessed it, 19519. So he says it's now been approximately 11 months since the state filed the request. Defendant has been given more time than he is legally entitled to in order to provide his alibi. They go on to cite a case, State versus Juarez, and say the state respectfully submits that we essentially remain in the same position as in July and August of 2023, and that, like in Juarez, we don't know how this is an alibi at all. So then he goes on to say, based on the above, the state respectfully requests that the court enter an order denying the defendant any further opportunity to add any purported claim of alibi and preclude testimony by anyone other than the defendant as to the defendant's absence from or presence at the scene of the homicide. Idaho Code 19519. So live it, love it, learn it, folks. Idaho Code 19519. Because Bill did not come to play. And that was an inadequate alibi response. So it's going to be interesting to see what Ann Taylor files in rebuttal to what Bill filed. And this is why pretrial is sometimes more interesting than actual trials. There's going to be a lot more maneuvering, folks, so put on your seatbelt. Okay, now that I got the alibi stuff out of the way, we also had some more filings involving the upcoming hearing on the 14th. We now have a hearing about the hearing, and we have some more information about the IGG, and kind of throwing a little seed out there again on the IGG. So let's take a look at what's been going on about the hearings, because the prosecution is wanting the hearing on the 14th closed, and the defense doesn't want it closed. So now we're having a hearing on the 2nd about it. So here is the order setting the motion hearing to the state's motion to close hearings and defendant's objection on May 2nd. That will be at 10 a.m. And that appears to be an open hearing from what I can tell. Yes, because it's being live streamed also on the YouTube. And what precipitated that was this. This was the prosecution asking for a motion to close the hearings pursuant to ICAR 32. So the prosecution is saying this motion is made pursuant to Idaho Court Administrative Rule 32G, and the likelihood that the state and the defense could be prejudiced by discussion or dissemination of information that has been stipulated to be filed under seal. Now, this was in regarding the fourth motion to compel, which was regarding the 14th and 15th discovery requests. So we believe that those deal with IGG and the CAST report. So this was Ann's filing, which is an objection to the state's motion to close hearings pursuant to ICAR 32G and the proposed scheduling order. And she talks about the constitutional right to a fair trial, and there's no reason that exists to prevent him from a public pre-trial proceeding. She says there is simply no legitimate reason that a motion to compel discovery should be shielded from the public. The process of sealing is being abused by the state and its law enforcement agents, including the FBI, to hide how discovery is being withheld in this case. Testimony and argument on information sought by Mr. Kohberger does not meet the narrow scope of what the state can shield from public view. Not only is there no authority to protect the FBI, other law enforcement agents in the state in this matter, this request to deny Mr. Kohberger an open hearing is a clear violation of his rights to a public trial. So that's going to be interesting because Judge has closed hearings before under ICAR 32. So it's interesting that Ann's saying that this doesn't fall under that. Now, the next thing is we got a little tidbit about what Ann thinks is going on with the IGG. So first, we had a motion to allow defense investigators to review the IGG. If you'll recall back at that other hearing about the IGG, after the judge had ruled that the defense could see some of it, they wanted it completely unsealed, and the prosecution said no, it should only be seen by the defense and then named investigators. So they have to name the investigators. So this is the motion asking for the investigators to see this. And they do not actually name the investigators. They are wanting the court to reconsider its decision and allow all of the defense team investigators to reveal the IGG, not just ones that they choose to name. So they are wanting this basically unsealed for everybody on their whole team. It says this hearing does not need to be sealed and is expected to take approximately 15 minutes. So they are requesting a hearing on this. Not sure if that's going to be part of the hearing on the 2nd. That's about the hearing on the 14th, because it's looking like IGG is part of the hearing on the 14th. So this is going to be interesting. But this is where it gets juicy. Anne has also filed a motion to unseal parts of the IGG materials. And this isn't about unsealing it for defense team and investigators. This is about unsealing it for the public to see. So it said the court previously entered an order allowing specific members of the defense team, including specific experts, to access the IGG material. She goes on to say the defense does object to sealing the rest of the information that has been disclosed. There is simply no legitimate reason that the way the IGG procedures in the case took place should be shielded from the public. The court provided no authority for sealing those materials. Most materials have been sealed in this case to protect the right to a fair trial. There is simply nothing unfairly prejudicial about the way in which the IGG was carried about the state and its associates in this case. In fact, the way of which the IGG occurred in this case has been made public in other cases. See State versus Hartman, and it goes on to talk about other cases. Now, this is the interesting part. This court's order is being abused by the state and the FBI to hide how the IGG was used in this case because what the FBI did violated its own rules and the rights of privacy of genetic genealogy companies have promised. Not only is there no authority to protect the FBI and the state in this matter, this refusal to permit Mr. Kohberger to expose this to the public is a clear violation of his right to a public trial. Wow. So Anne basically comes right out and accuses the FBI of violating privacy laws. Interesting. Now, while they may have, we don't know because we haven't seen everything, I failed to see how it relates to this case. Because the IGG was not used to obtain the arrest warrant. It was not used for the grand jury to get the indictment, and it's not being shown at trial. So if it were something that was used and she's trying to get it thrown out, yeah, that would be a big deal. but it wasn't used. So it can't be thrown out because it's never been submitted as evidence. It wasn't used to get the arrest or the indictment and won't be shown at trial. So the only thing I can figure she's doing is trying to poison the jury pool. Okay, so she wants this moved out of Latah County because she's saying he won't get a fair trial. But what she really means is he won't get a trial that's slanted in his favor. Because what she's doing by planting these little seeds, like saying the FBI violated privacy laws, is to get people that will be in the potential jury pool thinking that they can't trust the FBI, ergo, they can't trust Bill Thompson and the prosecution. She's shrewd. I got to give it to her. She knows what she's doing. But, wow. I told you buckle up because pretrial maneuvering gets pretty crazy. It's life in the fast lane.